Without a doubt, there's no question that a lot of people are going to be challenging the rule. I think there's more lawsuits to come.
Thank you for tuning in to Brach Eichler Talks, where we explore and discuss today's trending legal topics. My name is Joseph Cameron, and today I'm here with Brach Eichler member Keith J. Roberts, who will be providing a brief primer on the new FTC non-compete clause rule. Keith is certified by the Supreme Court of New Jersey as a certified civil trial attorney. He is also the chair of Brach Eichler's litigation department. Keith has extensive litigation experience representing clients in some of the largest, most complex, and high-exposure cases with an in-depth understanding of the law and a command of the facts to strategically achieve his clients' litigation objectives. As a member of the healthcare team at Brach Eichler, Keith is often called upon to represent hospital systems, surgical centers, medical practices, and a wide array of healthcare professionals in complex litigation matters. How are you doing, Keith?
Oh, good afternoon, Joe. Thanks for having me.
So we're just going to hop right into this. So this is a really interesting rule that just came out. It's big news. It's going to affect a lot of people. So the first question is, what is the purpose of the new FTC rule as it concerns non-compete clauses?
Well, that would depend on who you're asking. But from the point of view of the FTC, at this point, it seems that when you look at the commentary around the rule and the justification for it, since at least the 1970s, non-compete clauses throughout the country, and depending on which state you're in and the jurisdiction, have become more and more prevalent. And as a consequence, a lot of litigation has arisen. And for the most part, they've been uniformly enforced, particularly in this state. They're very fact sensitive to enforce. But what we've seen has been a contraction of competition, at least in the view of the FTC. And as a consequence of that, they feel that marketplace dynamics and other issues relating to innovation, free market competition, have suffered as a result of non-compete clauses that have been widely enforced in many jurisdictions. And even at the federal level, it's become more and more difficult to challenge these clauses as either violating antitrust or being improper or difficult to enforce as a matter of law. In other words, it's become very difficult to set these clauses aside. And as a consequence of that, it has, in view of the FTC, drastically restrained free market competition against the trend of a lot of market dynamics. I mean, that's the best and most simplistic way I could explain what the purpose of the rule is. What we're looking here to do, in view of the FTC, is to open up the economy and allow competition to flow as freely as possible, and at the same time use other mechanisms to protect companies or employers as it concerns their confidential information or trade secrets without restricting the ability of a person to move in the free market economy and seek employment, or more importantly, open up businesses of their own, which would not be considered unfair competition, just competition that would be healthy for the country's economy.
Since this has such widespread implications, I've heard a lot of information and I keep seeing more news stories about it. But what are the key takeaways from the new FTC rule?
Well, there are a lot of key takeaways, but from a high level, first, the rule broadly tracks what was proposed in January. So what the rule is attempting to do is to void restrictive covenant clauses effective September 4th, if in fact the rule were to become adopted from an effective date at that point, meaning legal challenges, which we'll discuss in a moment, would be unsuccessful in preventing that. The rule would prohibit non-compete clauses, all but for senior executives, which essentially would be policy-making people and those receiving compensation in excess of $151,000. For that group, there would be a carve-out for existing covenants. But going forward, you wouldn't be able to restrict those people in covenants either. Now, the other important takeaway in the rule is that non-competition and such related clauses will be permitted for businesses that sell their assets. It has to be what we say is all or substantially all of a business entity's operating assets. So in that instance, where a sale would take place and someone would pay a substantial sum of money to acquire assets. The seller wouldn't then be able to turn around and make the transaction without its fair market value price tag by then circumventing it and competing against the buyer, thereby substantially, injuring and depreciating the asset for which was just purchased. So that makes a lot of sense. Another important takeaway from the rule is that it will include not only employees but independent contractors. Now, the rule would not include franchisees in the context of a franchisor-franchisee relationship, but the employees of those entities would be included. What will happen going forward in terms of causes of action that you may have for existing covenants, if the cause of action arose prior to the time that the rule became in effect, you would be able to pursue that potential claim or lawsuit. Outside of that, you would not. So it's going to have a significant legal impact on what's occurring not only in New Jersey, but all the states in terms of what legal remedies you'll be permitted to pursue. The rule will also require that you provide notice once the rule becomes effective to your employees, which has been defined as clear and conspicuous notice to workers, indicating that their non-compete clauses are prohibited. So essentially, you're voiding non-compete clauses that are currently in effect. Another important thing I'd like to mention as a takeaway about the rule is who it will apply to. So very few employers will fall outside the rule's jurisdiction. The rule identifies certain institutions, savings and loan, federal credit unions, common carriers. There are certain federal-based employers that will fall outside the rule, as well as companies or organizations that are carrying on their business not for their own profit. In other words, entities that are true nonprofit organizations. However, simply having 501c tax status would not automatically indicate that the rule doesn't apply to you. It would be insufficient to rely just upon that factor. In other words, simply claiming that you have nonprofit status under the tax code would be insufficient. So that is something to be mindful of, especially when we're looking, for example, at a hospital system that may have a 501c3 designation under the tax code. It's going to be specious to jump to the conclusion that automatically that would exempt you from the rule.
So you mentioned hospitals. It's going to be really interesting seeing how it affects the medical industry. What do you think the impact will be on New Jersey physicians, medical practices, and facilities?
Yeah, it remains to be seen. We're going to see what happens with the rule effective date number one. But as we look at it now, in the event, putting legal challenges aside, if the rule is adopted as is, there will be a significant impact upon the medical community and the professionals practicing in New Jersey. There's no question. It would void most restrictive covenants. There'd be an exception for a limited period of time where you have contracts in place for senior executives, policymaking individuals at a certain threshold. There'd be an exemption for those existing covenants, but once they expire contractually, that would be the end of those covenants as well. So just like any business, there would be a significant impact on the industry in that it would change behavior in the industry. Since there would no longer be covenants, it's going to impact. It could impact a lot of things, from everything from how transactions are structured to compensation to reacting to market trends of how competition will then behave where it was controlled before, won't be controlled any longer. The idea, according to the FTC, would be to free up market regulation and free up market competition. And they estimate that savings could occur from this by expansion of available resources and competition in the marketplace from anywhere between $75 to $200 billion a year. That's a very substantial number that they estimate would be savings as a result of allowing free market competition, particularly in the healthcare industry. So the impact could be very substantial. Exactly what it will be and what it will look like, I think there are just way too many variables to make that judgment now.
So one of the big things that immediately pops into my mind is current and future lawsuits. So what impact will the rule have on existing or future lawsuits in New Jersey relating to non-competition clauses?
That's a very good question. So there's the obvious answer that it'll have a drastic impact if the rule is adopted on September 4th. You will not be able to bring a claim that you could have once asserted, of course, unless you have an exception, meaning that you're in a contract with a senior executive and you fit the criteria, and that contract, through its term of expiration, will preserve your potential cause of action. Outside of that, if the rule's adopted as written, it'll have a tremendous impact. Once the effective date is there, you will not be able to bring a cause of action for violating a covenant that no longer exists. A lot of people have asked me the question about, well, what will be the impact of the rule now that it's out there but not yet adopted? That remains to be seen. There's one side of the fence that's going to assert the position it should have no impact, given that legal precedent is well developed in New Jersey, which indeed it is, prior to the rule, and before its adoption, it shouldn't have any impact. There's going to be another camp that provides a lot of argument and basis and weaving into their legal and factual analysis of their claims that this rule is, insightful and illuminates a lot of legal issues that have now come to light that the government has taken a hard stance on, and thus it should be persuasive. We know that if the rule is adopted on the 4th, the impact will be clear. You will not be able to assert the claims, as I've explained earlier, unless, of course, you have an exception. So it remains to be seen what the true impact will be on lawsuits until we know where is the resting place for the final rule. What date is that? What does the rule look like? How does it impact lawsuits in terms of the language in the rule upon final adoption? And we just don't know those things right now. But I imagine that not too far off in the future, we'll have a lot more insight on that.
And I have a feeling I know the answer to this final question, but do you anticipate legal challenges to the new FTC rule?
Well, there's no question there will be legal challenges to the final rule. They are already in motion. So there are 3 cases that I'm aware of right now that are being reported on. One in the Northern District of Texas, one in the Eastern, and another one in the Eastern District of Pennsylvania. So 2 in Texas and 1 in Pennsylvania. And they all challenge the rule along the same grounds, a little bit different in how they approach their arguments. Certain parties are seeking to enjoin the rule, meaning they want an injunction preventing the rule from going into effect. One of the cases is on an expedited track to have that happen. Limited discovery would end in June, and because there really doesn't need to be fact discovery because it's going to be a legal argument that's going to be before the court. So really the exchange of information would be very limited. It's going to be essentially tee up the legal arguments on the injunction and argue it. So that could happen as early as the end of the summer. We're going to have a ruling on whether or not an injunction will be issued because, of course, with the September 4th date, you only have until that time to enjoin the rule or not. The legal challenges are focused on the lack of rulemaking authority by the FTC, meaning that, hey, this did not occur by an act of Congress. It occurred through a federal agency that really can't drive policy, which is essentially a substitute for statutory action or congressional action by writing and adopting a law rather than procedural issues normally vested in the FTC, as well as unlawful interpretation of the unfair method of competition, which is all throughout the rule. There's also challenges concerning that this authority could not have been delegated to the FTC, meaning that an act of Congress would have been required to go as far as they did in terms of a categorical prohibition of non-competes. One challenge concerns the non-delegation doctrine. The pleadings in the cases that I've mentioned talk about how there is a categorical prohibition of non-competes, which would have required Congress to act, and this agency did not have the ability to do that. The challenges also discuss the unlawful retroactivity, in that the FTC does not have really authority to retroactively rule make especially on something affecting the United States economy and state law as much as this rule does. So it raises serious questions under the Fifth Amendment of the Constitution. That issue's been pled. And then the other common legal challenges which concern, the rule itself is arbitrary and capricious, and that the structure of the FTC and what it is empowered to do does not permit it to engage in such rulemaking authority. So those are the high-level arguments that have been pled. So they will be aggressively pursued, without a doubt, given the importance and the potential massive impact of this rule.
It sounds like it's going to be an interesting summer.
Without a doubt. There's no question that a lot of people are going to be challenging the rule. I think there's more lawsuits to come. There'll be a very close eye on the legal precedent developing. And in one way or another, there seems to be momentum that this issue will not go away. So it will be a fertile ground for discussion and action for lawyers and many industries for time to come.
Thank you so much for taking time out of your busy schedule to give everybody this important information, Keith.
Joe, thank you so much.
If any listeners have any further questions or concerns about how the rule may impact litigation, either to be initiated by your company or against your company, you can reach Keith Roberts at kroberts@bracheichler.com or 973-364-5201. Thank you for listening, and for more information, please visit bracheichler.com. Brach Eichler LLC is a full-service law firm based in Roseland, New Jersey. With over 80 attorneys, the firm is focused on the following practice areas: healthcare law, real estate, litigation, trust and estates, business transactions and financial services, personal injury, criminal defense and government investigations, labor and employment, environmental and land use, family law services, patent, intellectual property and information technology, real estate tax appeals, tax, and cannabis law.